Aha. Meeting is now streaming live on YouTube. I've got a message that popped up on my screen. I don't know if y'all can see this too. By staying in this meeting, you consent to sharing your information, including audio and video. Users with access to the third-party service, YouTube, can watch or share content with others. Okay. So, can we get a link to that third party so folks can Here we go. Yep. It is up live on YouTube. The account is at Judge Kevin Farmer 7165. I see 2 people watching. Looks like we got some more people coming in. So y'all are more than welcome to join that as well. I'm not going to ask you to hit the subscribe and like button. Okay. First off, do I have a case number, Mr. Kaufman?
Your Honor, I've not received that from the clerk yet. Obviously, we filed very late at night, and we just have the submitted envelope numbers, but no case number.
Give me the submitted envelope numbers.
Yes, sir. That number is 164-85887.
164-85887.
Yes, Your Honor.
Are you going to be arguing on behalf of the petitioner?
Yes, Your Honor.
And who do I have on behalf of Fulton County?
Stephanie Andres. Oh, sorry. My bad. My bad.
I think the judge was asking for attorneys. Your Honor, this is Sue Joe on behalf of Fulton County.
All right. Thank you, Ms. Joe. All right. I'm going to go out on a limb and say, and when I ask, do both parties want this recorded? I do have, you'll see Mr. Forte, his name down in the corner. He is my assigned court reporter.
Yes, Your Honor, we would like takedown, please.
Yes,
Mr.
Your Honor.
Hoffman.
Yes, Your
Okay.
Honor. We're happy to share it.
We will share in the cost.
Okay.
And Your Honor, this is Kurt Castor. I'm representing the Democratic National Committee and the Democratic Party of Georgia. And it's at some point early in the hearing, I'd like to move to intervene in the matter.
Okay. Well, I hope everybody's appropriately caffeinated this fine Saturday morning.
Not yet.
Not yet.
Not enough.
First off, I want to address how this came to be. I want to put everything on the record. We're going to get everything above board. I received texts last night from Mr. Kaufman, in which he also copied Mr. Oh, I don't see him.
Mr. Siegelman, Your Honor.
Yes, he copied Mr. Joe Siegelman, who evidently had represented Fulton County in similar in election-related issues previously before the Fulton County Superior Court. I did not respond to any of those emails or any of those text messages. There was a string wherein Mr. Kaufman and Mr. Siegelman went back and forth. I did not respond to any of those emails. I mean, again, sorry, texts. Mr. Kaufman also has my cell phone number and contacted me at late last night, approximately 10 p.m. Let's see, 10:34 p.m. I missed his call and he left me a voicemail. I have not read nor listened to that voicemail in the interest of not having ex parte conversations with anyone. The only messages I have responded to have been to my work email when Mr. Kaufman emailed me with a copy of the pleadings, with some other names attached that I see on here. I think Miss Andres may have been, no, I think Miss Brumbaugh was included on it. Is that correct, ma'am?
Yes.
Let's see. Instead of guessing, we'll just, we'll actually look at it. Mr. Kaufman CC'd Mr. Siegelman, Mr. Kuchers, myself, and Miss Brumbaugh. I hope I got that right, Miss Brumbaugh.
Your Honor.
I then responded saying I would have this hearing at 8 o'clock. I BCC'd my staff on it so they would know, and they are on. Ms. Parsons is my staff attorney. Ms. Bentley is my judicial assistant. And as I mentioned earlier, Mr. Forte is my court reporter. I have since received additional emails. I did receive your email, Mr. Kastorf, indicating that you represented the DNC, and you are obviously welcome to join us. I have read the petition, which appears to there's some confusion as to the original. The petition indicates that it's traveling under 21-2-381 and 21-2-385. That's in the introductory, that's in the title of the pleading. But then it immediately in the body starts referring to 21-2-382, not 381. 381 is the method by which folks apply for absentee ballots and how they're created and delivered to those voters. Making of application for absentee ballot, determination of eligibility, furnishing applications to college and universities, and persons entitled to make an application. 382 is additional buildings as additional registrar's office or place of registration for receiving absentee ballots and for advance voting. And the plain language of it states in C1, all drop boxes shall be closed when the advance voting period ends, as set forth in subsection D of code section 21-2-385. Subsection D of 385 discusses there shall be a period of advance voting that shall commence. The commencement isn't really at issue here, so I'll just skip to the end. And shall end on the Friday immediately prior to each primary election or runoff. That date obviously would have been yesterday. It gives some leeway to the county to extend voting hours through 7 p.m. But the last sentence of D1, except as otherwise provided in this paragraph, the registrars may extend the hours for voting to permit advance voting from 7 a.m. until 7 p.m. and may provide for additional voting locations pursuant to 21-2-382 to suit the needs of the electors or the jurisdictions at their option. Those would be drop boxes. However, provided, that voting shall occur only on the days specified in this paragraph, and counties and municipalities shall not be authorized to conduct advance voting on any other days. I believe that, Mr. Kaufman, is the gravamen of your complaint.
Correct.
Now, okay. Now, and Miss Sue, I'm sorry, Miss Joe, my apologies, ma'am. Have you had a chance to review Mr. Kaufman's petition?
So, Your Honor, thank you. I actually became aware of this at about 3:30 a.m. this morning, so just a few hours ago. In reviewing all of the correspondence that had gone back and forth, I realized that from our perspective, Ms. Brumbaugh, as advice counsel for the Board of Registration and Elections, had tried valiantly to assist, but she is not engaged to represent Fulton County, which takes this outside the scope of her representation. Mr. Joe Siegelman, who has represented the county in other I guess, cases involving the same plaintiffs and attorneys on the plaintiff side. This is a new case that would require board authority for me to be able to engage outside counsel. Because the filing was done late in the evening, I believe it was after 10 p.m. last night, and the hearing is at 8 a.m. To be honest, we have reached zero of the other attorneys in my office who would normally handle litigation on behalf of the county. So I'm afraid you're stuck with me this morning by default, but we certainly wanted to be able to appear and respond to the plaintiff's concerns and to reassure the court of our position and the state of affairs regarding the allegations in plaintiff's complaint. So I'm here representing the county. I have not had much opportunity to review, but I think I will be able to concisely respond to the allegations in the complaint.
Okay, and the allegations in the complaint are, now, it is the Exhibit 1, which is attached to the petition, is a screenshot of a Fulton County
website.
Hold on just a moment.
Mm-hmm.
That indicates, excuse me, y'all. Four election offices around Fulton County will be open throughout the weekend to accommodate voters seeking to hand return their absentee ballots. So it does not mention that drop boxes are going to be open at all.
No, Your Honor, and I think if this is the portion of the hearing where I can address the court, I will say I think we can make short work of this. I understand that the plaintiffs have what I presume to be good faith concerns, but the hearing, the posting itself does not mention drop boxes. Only one of the four listed locations ever had a drop box, and that was at the headquarters. That drop box was closed at the end of advanced voting per the statutory requirements and removed from its location. So to the extent that I understand the pleading to be based on essentially one concern, which is that ballot boxes have remained open beyond the period of advanced voting, that has never been the case, and it has never been part of the announcement that was posted yesterday at 1:42 p.m.
Okay. Prior to the close of business, by the way, while I was still downtown in Atlanta and had an open courtroom.
While we were in the hearing,
Miss Williams, good to see you again, ma'am. I believe we spoke with each other yesterday, did we not? You as well, Mr. Kuchers.
Good morning.
Okay. Mr. Kaufman, Fulton County is indicating they don't have any drop boxes open.
Well, I will address that. In 385, 21-2-385, there's absolutely no provision, which is the procedure for voting absentee ballot, that allows for hand delivery to the registrar. And in fact, the legislature in SB 202 specifically created the ability of the drop boxes, the sole method, with a chain of custody provision and safeguard as for the way that the ballots can be received other than by mail. And so you have by mail and into the boxes. So
I'm going to point you to, if you look at 21-2-385A, after it's all filled out, talks about how you put envelope in envelope. Such envelope shall then be securely sealed, and the elector shall then personally mail or personally deliver same to the Board of Registrars or absentee ballot clerk, provided that mailing or delivery may be made by elector's mother, father, grandparent, aunt, uncle, brother, sister, spouse, son, daughter, niece, nephew, grandchild, son-in-law, daughter-in-law, mother-in-law, father-in-law, brother-in-law, sister-in-law, or an individual residing in the household of such elector. That seems to indicate that personal delivery to the registrar and not to a drop box is kosher.
Well, even so, you then
And more
fall
than
in,
kosher, lawful.
well, you fall into the issue of then under 385 D1B, which about the geographic disbursement of other additional locations other than the main office of the registrar.
No, that refers to drop boxes. There are no drop boxes here. Drop boxes are off the table. All the drop boxes have been picked up.
And Your Honor, if I may add that the SOS guidance that was published on October 30th advises folks who have absentee ballots that they have not mailed yet, given the shortness of time until the election, do not mail your absentee ballot. Take it to a local county election office. So even the Secretary of State's office recognizes that at this point, the best course of action with an absentee ballot that wasn't mailed timely or well in advance would be to take it directly by hand. I would also note that the code section 21-385 D1B that Mr. Kaufman is relying on says advanced voting will be limited to certain hours to correspond with advanced, that will be limited to certain hours, excuse me. Advanced voting is not the same as turning in an absentee ballot. They may coincide in location in terms of where you can turn in your absentee ballot and where you were able to advance vote. But advanced voting is done now, and that is a completely separate method of voting from turning in your absentee ballot, which per 21-386A1 F as in Frank,
Hold on.
if it were mailed, could be turned in through the end of the election day and still be valid and counted.
21-386.
A like apple, 1 F as in Frank.
Right. And I apologize for looking. I'm working on two screens here, folks. I'm sure some of you are as well.
Your Honor, Kurt Castorp, if we may have an opportunity to present briefly on behalf of the DNC, I think there's a statute that directly authorizes exactly what Fulton did here.
Well, why don't you have a side chat with Miss Joe? And Miss Joe, what code section you were? 386.
A like apple, 1 F.
A1F.
Yes, Your Honor. And I'm looking
Well,
at
and let me ask petitioner, if a absentee ballot was mailed in and received at the registrar's office today, Sunday or Monday, are you willing to concede that that would be a valid ballot, Mr. Kaufman?
Yes, Your Honor. The issue is
so they can mail it in and it can be received, but they can't go down and hand it in.
The issue is also where the additional locations are, because they are not geographically spread out across the 78.
Those have that refers to the drop boxes. That the geographical dispersion is the drop boxes.
And even if it did apply to this, which it does not, we agree with the court, they were actually spread out geographically. It's the central hub and north and south.
We have the North Fulton Annex, the South Fulton Annex, the main Fulton County Government Center, smack in the middle of Fulton County. And then we have the registrar's office, which I believe is Union City.
Correct.
Okay.
And only one of those, we contend, out of the three are in the northern part of the county. All the other three are from downtown south, which in the 78-mile-long county is not geographically dispersed. And so
would you have the respondent open more locations in the north to receive ballots?
No, we would contend that they should only have maybe one in the south at this juncture, or none at all, because the chain of custody concerns are great as far as receiving ballots and making this announcement, which, by the way, was announced at 5 o'clock yesterday, We have poll watchers that we would have had to have gone out. This clearly changes the time and conduct of the election at the last moment to have this announcement out.
Hold on.
So, Your Honor,
I'm reading 386 F A1. All absentee ballots returned to the board or absentee ballot clerk after the closing of the polls on the day of the primary election shall be safely kept unopened by the board and then transferred to the appropriate clerk for storage for a period of time required for the preservation of ballots used at the primary or election, and shall then, without being opened, be destroyed. So if you're late, we're going to destroy them.
Right. But I don't think that has anything to do with our petition, Your Honor.
Your Honor, while I'm happy to share information with Ms. Chow, we would like to formally move to intervene and make a presentation. I don't think the formal intervention motion should take much time at all, both because Fulton Superior has granted us intervention in several cases already, and also because I don't believe Mr. Kaufman will object to our intervention motion.
Well, let's find out. Mr. Kaufman, any objection to Mr. Kastorf coming on in?
We don't oppose it, is the official position of the party.
So no objection is what I
no
heard.
objection. Yes, exactly.
Mr. Kastorf, welcome to the party.
Thanks. And if I may briefly present, I do think I have some statutory language that will be helpful to this court.
I like reading code sections.
So Georgia law expressly permits Fulton County to establish, quote, additional registrar's offices or places of registration for the purpose of receiving absentee ballots, provided these locations meet certain basic requirements, such as being government buildings or previous polling locations.
Now you're looking at section 382, aren't you?
Yes, 382A, and that's precisely what Fulton County has done here. That provision expressly authorizes the creation of these locations and tracks the language on Fulton County's website, which is that they are creating registrar's offices for the receipt of absentee ballots. Despite this provision directly on point, Georgia GOP has been arguing that two other portions of the election code restrict Fulton from doing what the General Assembly has authorized it to do under 382A. But there's at least two very serious problems with those arguments. The first is that 382A explicitly supersedes the other provisions cited. The very first clause of that subsection reads, quote, any other provision of this chapter to the contrary notwithstanding. This language makes clear that even if other portions of the election code could be read to restrict Fulton County from establishing absentee ballot receiving locations, courts may not read them that way. And I would just note as an aside, the GOP has relied on identical statutory language in the ballot access cases. In the Green Party case, they used the exact same clause in another provision to argue their position on ballot access. The second serious flaw of GOP's argument is that neither of the other provisions it cites is at all relevant to whether Fulton County can establish additional registrar's offices to receive absentee ballots. This court has already keyed in on the fact that 221.2.382C talks about drop boxes. Drop boxes are not the same as additional registrar's offices. They're treated separately under the code in separate code provisions. There are separate titles for those code provisions. And it logically makes sense to treat them different because the procedures that the General Assembly would deem relevant to a voter slipping a ballot into an unmanned ballot box is entirely different than the procedures when they're handing it directly to a county election official. The second code provision they cite is 385, which addresses when advance voting can be conducted. That provision might theoretically be relevant if absentee ballots could be cast only during advance voting, but there's no such restriction in Georgia law. As this court is likely aware, absentee ballots can in fact be returned to the county up to and including Election Day. And if ballots returned on Election Day are not late, then clearly ballots returned in advance of Election Day are not late. We think that 382A is directly on point here. Fulton followed the law to a T, and this court should deny any relief.
Mr. Kaufman?
Yeah. Well, 382A also cites 381 as well as the advanced voting under 385. Additionally, when you go under, you have A and then B, which also brings in the 385.
Can we stop you there? Wait. Any other provision? This is 382A.
Right.
Any other provisions of this chapter to the contrary notwithstanding, which means this one gets a little bit of special treatment. The Board of Registrars may establish additional registrars' offices, excuse me, y'all, or places of registration for the purpose of receiving absentee ballots under 381, and that's just the creation and how they're applied for, et cetera. So they can do it for that, for the purpose of receiving ballots, and also for the purpose of advanced voting under 385.
Correct.
Mr. Kastoff, you're saying we're not talking about advanced voting anymore. We're talking about what came before the word "and."
That's correct. There's no reason to have both of those clauses unless these deputy registrar's offices can receive absentee ballots.
Because absentee ballot is different than advanced voting for the purposes of this statute. Is that your argument? No, I'm going to get you, Mr. Kaufman. Don't worry.
Yes, that's correct. Advanced voting in this particular context refers to early in-person voting. It sets specific times when it can happen. There are separate statutory provisions referencing absentee ballots that clearly establish they can be received up to and including the election day until the close of election day.
Okay, Mr. Kaufman.
Yeah, here's the problem with that analysis is Georgia has two kinds of voting. It's either day of or early. You can either be early in person or early absentee. And so here, that's where I think the disconnect is. And because this is now just absentee ballot, early voting's over. That's it. The next time that they can be delivered is day of voting or by mail. And so that's the disconnect. There's no third window of, well, whenever you feel like it's still under the early voting provisions and not day of voting provisions. And that's the issue.
And Your Honor, what Mr. Kaufman is referring to is that when Georgia created early in-person advance voting, the way they set that up is to say, the way we're going to set this up is as a technical and literal matter, you're showing up early to vote, you're applying for an absentee ballot, then being allowed to vote. And in previous election cycles, if this court has ever voted early, you might know you did in fact fill out an absentee ballot application and vote. That's now been streamlined onto the poll pad process. But what he's referring to is simply the administrative process by which Georgia set up early in-person voting. That does not get rid of ample statutory language indicating that absentee ballots are an available remedy to Georgia, that they could be mailed in, they could be handed in person, and the deadline for receipt is the close of election day, not the close of advance voting.
Our point is that hand delivery would then has to be done on those voting days. And now that those advanced voting days are over, your next hand delivery is when on election day. That's the disconnect, Your Honor.
I think the disconnect, Your Honor, is that Mr. Kaufman conflates advanced in-person voting and the ability to have your absentee ballot received by the elections department at any time, all the way through the election day.
And I'm also, here's one of the things I'm really struggling with is if it's okay for the postman or postwoman to deliver an absentee ballot on Saturday, probably not Sunday, or Monday, but it's not okay for the voter themselves to do it. And then we run into, as other states have, oh, hey, if it's postmarked by election day versus received by election day, and obviously, the code appears to take that into account. It's got to be received.
Correct.
So there's no postmark. So that fight's not going to happen here. But it does appear, it's curious to the court that it's okay for someone other than the voter to deliver their absentee ballot, not on election day, but after early voting has closed. But it is not okay for the voter to personally deliver their absentee ballot during that same time frame.
And the
which
reason
is arguably more secure.
Well, the reason for that, Your Honor, is because of the chain of custody. And so, the ballots can be tracked.
Aren't you streamlining the chain of custody by taking the U.S. Postal Service out of it?
Well, actually, you're not.
One at a time, please.
Actually, you're not. And the reason is twofold. One is with the Postal Service, they can be tracked. Two is when they hand deliver it just to a random, apparently registrar agent, one of 4 locations, without it being in the secure drop boxes. You don't have the same chain of custody of each day they're checked, each day that they have to be cleared, each day they're logged, and that's why the legislature specifically wrote the Dropbox provisions into code in 2021, just for this exact reason. So while it may seem not logical, but that is why those are the 2 methods of returning the ballots in this manner during these specific times, because they are actually have specific log times that are required by statute in the morning to be seen that they are when the poll opens each early voting day, and at the end of the day close. And so that is not here when you have hand delivery ballots on weekend extended hours that are announced within less than 24 hours of this apparently happening. So that's the issue. And the other issue, Your Honor, is this was decided without a board vote. In fact, that's why Mr. Heekin is here, and Ms. Adams, the 2 of our board members, had no notice of this until it was just sent to them as a press release. So I mean, there's an authority issue and a last minute decision that affects how the election is conducted, and that is of great concern to the Fulton County Republican Party and the Georgia Republican Party to have that. And it makes it very difficult for poll monitors, poll watchers, whose job is to be able to meaningfully observe. And it's one thing to observe a drop box, but it's one thing versus having to observe an entire building to see where someone may or may not find a registrar to hand it to them without a drop box. And so that is exactly why the legislature drafted this statute in the manner that made it much more specific as to, and that's, we spent a lot of time on 382A, but B1 is all about the drop boxes and how they're marked, how it's labeled, how someone would know to find it, that that's the correct person and place to place it in. And then if you go into 4, it talks about the timing of the checking of them, which is what that chain of custody issue is that I alluded to before.
Your
Mr.
Honor.
Kaufman appears to be making a policy argument as to why absentee ballots should be time limited in the same way. Hand receipt of absentee ballots should be time limited in the same way as drop boxes. The problem is none of his argument about legislative intent and why it should be that way is located in the statutes. He also doesn't account for why both the statutes and the Secretary of State's recent guidance specifically provide for hand delivery of your absentee ballot through the day of election.
Well, there's 2 reasons for that, Your Honor. One is the Secretary's guidance is just that. It's guidance. It's not law. The law is clear on checking IDs when things are delivered and all these other aspects that are now changed. The other issue is there's supposed to be uniformity in how these elections are conducted. What Fulton County unilaterally decided to do yesterday is not the same as what the other 158 counties have decided to do, and that is improper from a state level of the uniformity of how elections are conducted.
You're getting back into policy, Mr. Kaufman.
Well, the court had, in all fairness, the court had asked what he couldn't understand the policy decision between postal delivery and an individual delivery, which is why I had brought that aspect to the court. But the uniformity is not a policy decision. That's what the law requires of how the elections are conducted in a uniform manner throughout our 159 counties. And in fact, that's the entire charge of the SCB, to oversee that uniformity, not in a last minute, hey, we've extended hours of the weekend in these 4 places.
Your Honor, if I may very quickly make 2 points. The first is that Mr. Kaufman is misstating the relevant legislative history of this provision. The ballot drop box provision precedes 2021. Prior to the recent amendments to the Georgia Election Code, there was subsection A, which provided for hand and turn in of ballots, and subsection C, which provided for drop boxes. What the General Assembly did in 2021 is it said, we think that the drop box procedure, not the hand-in procedure, but the drop boxes, because these are unmarked boxes outside of government buildings that people could stick a ballot into at any time, should have additional chain of custody protections added. And so they added additional restrictions saying that they have to be outside advanced voting locations, that they need to be monitored, that they need to be lighted, etc. That amendment modified that provision. The General Assembly made no change to 382A and did not indicate any problem or concern about the chain of custody contained in that provision. So the statutory history argument simply isn't accurate. But I would also note that while the election code is admittedly complicated, this court doesn't need to engage in a deep dive into the election code because 382A is a self-contained provision that explicitly says it supersedes other adjacent codes that could arguably be relevant to this question. And 382A clearly authorizes locations for the receipt of absentee ballots.
Your Honor, first of all, I hope maybe write that 2021 bill, but okay, but we can talk about the legislative intent. But 382B also begins with the exact same any other provisions of this chapter to the contrary notwithstanding. So it's also a self-contained magic language, which then brings in 381 and 385 again. So the problem is when you read this, and then if you look at the most recent statutory, which is the about the drop boxes, that Mr. Kastorf is correct. That is what the legislature did most recently, which is why because it was not even something that existed until it was a creature of the Secretary of State and the SEB during COVID. So what happened was in 2021, the legislature codified the concept of a drop box, and with the
wait. Okay, look, stop. We're going all legislative history again. And I know Mr. Kastorf said, I'm reading the statute. Okay, that's what I'm doing.
Yep.
And 382B, yeah, also has that any other notwithstanding, and it talks about population. Red herring. That's inapplicable to our case, unless you're alleging that Fulton County has less than 550,000 people.
No, Your Honor. What I was saying is if you continue, or absentee ballot clerks, where it talks about where they should be, and then it's citing and brings into 385, which is, of course, the only section that is titled procedure by voting by absentee ballot or
no.
voting.
385, it says, and for the purpose of advance voting, not absentee voting.
No, it says
advance voting under, you cannot walk in and vote.
It says a procedure for voting by absentee ballot, advance voting. That's the title of 21-385.
I'm reading the plain language of 382. The Board of Registrars may establish additional registrars' offices or places of registration for the purpose of receiving absentee ballots created under code section or under 21-2-381. And also, for the purpose of advanced voting. Correct. Those are separate things. One is receiving absentee ballots. The other is advanced voting. Now, that goes you to 385.
Correct. And
it says advanced voting can't happen after Friday at 7.
Well, it also is the procedure for voting by absentee ballot. It's both provisions. 385 is titled Procedure for Voting by Absentee Ballot, semicolon, advanced voting.
Right.
And so this is how.
And in D, 385D, there shall be a period of advanced voting that shall commence, and it sets forth the timeline.
Correct. And it's the
correct. However, up in A, it says such envelope shall then be securely sealed, and the elector shall then personally mail or personally deliver same to the Board of Registrars or absentee ballot clerk. That's a separate code section. That's a separate subsection than D.
Correct.
They separate absentee ballots from early voting as well in 385. But you're right, that code section does address both absentee ballots and early voting. You're correct. But it separates them. It acknowledges that there's a difference between the two. Yes.
Honor.
I agree with the court's reading of 385A, of course.
Your Honor, may I say that plaintiffs here are asking the court on less than 12 hours notice to grant extraordinary emergency relief but yet after this hearing has gone on for at least 30 minutes now, have pointed to no statutory basis to support their position that absentee ballots can only be received until the end of advance voting, and then paused for 3 days and then resume again on election day. That is not what the statute says. Mr. Kaufman has pointed to no statutory authority to support that position, and that is the basis. That position is actually beyond what his pleadings say. His pleadings are simply about ballot boxes, which I think we all have gotten past because that's not factually an issue.
Well, Your Honor, obviously it says hand return their ballots. It doesn't mention ballot boxes. We've talked about, last minute.
Hand return their ballots to the registrar.
Well,
not to a drop box.
It doesn't.
There are different security issues, and the fact that you tried to made it seem like going to the registrar's office is actually less secure than going to a drop box.
Mm-hmm.
Potentially under these scenarios, yeah. I mean, it is potentially. First of all, it says nowhere in this notice that it's going to be hand delivered to a registrar or hand delivered. When it says seeking to hand return their absentee ballots, I mean, I don't know. They certainly had Dropbox locations there. We've talked about last minute filing.
Only one of the 4 locations had a Dropbox ever, I heard, and that one has been removed.
That's what we're hearing.
And that one Dropbox location, Miss Joe, was at the registrar's office in Union City?
Yes, Your Honor.
Okay. So, Mr. Kaufman, I'm prepared to say that any absentee ballot that shows up in a Dropbox today, tomorrow, or Monday, that's gone. I got no problem with that, because
we would
subsection D is real clear that drop boxes die the same time early voting does, Friday at 7. Ms. Joe,
we would agree with that too, Your Honor.
You would agree with that? That goes away.
Absolutely. We are abiding with that.
You see, look, we can agree on something.
Yes. We just weren't aware that we are all in agreement on that.
Okay. So Dropbox is bad on Saturday, Sunday, Monday.
Correct.
Handing in personally to the registrar via the voter or the mail carrier. Okay. Mr. Kaufman, you seem to be positing that, okay, if the mail carrier does it, but not if the voter does it.
By mail. We have absolutely no issue with it by mail.
The problem
but the voter
is
itself, the voter, him or herself.
The problem is that Mr. Kaufman is arguing that it shouldn't be allowed, but he hasn't pointed to any authority that prohibits hand delivery of absentee ballots in between the end of advance voting and election day.
I think Ms. Joe has put words in my mouth. Our issue is the last minute notice and change to opening additional locations within 12 hours. With less than 12 hours.
That wasn't the gravamen of your complaint.
No, but it's one of the main issues of concern that changes our ability to have meaningful poll watchers having a.
Mr. Kaufman, you managed to get me on the phone, Mr. Siegelman on the phone, a whole bunch of people ready here, 2 of the board members here by 8 a.m.
Yes, sir.
I have no doubt of the petitioner's capacity to put boots on the ground. Okay. You got 4 locations. Mr. Kaufman, you or I could be at the North Annex in about 10 minutes, I imagine. I know I could be. And it's, the geographic location, that's the Dropbox argument as well. Yeah, your prayer for relief, not permit persons to hand return their absentee ballots, not to accept absentee ballots in drop boxes on November 2nd and 3rd, and 4th. And Ms. Joe is conceding that point, correct, ma'am?
Yes, we agree that that's what the law states. I just don't agree that we are in violation of it and that this hearing was necessary on an emergency basis.
Okay. Okay, well, all right. And then the obligatory attorney's fees argument. I understand that too.
Obviously, we object to those.
Yeah.
And one thing I'd like to point out, Your Honor, if I may, is that it has been exceedingly difficult to be prepared and responsive to Mr. Kaufman's complaint allegations and prayers for relief, because it seems to be a moving target, and it always seems to range beyond what is contained.
Well, hey, Miss Joe, when was the announcement made that these registrar offices would be open? When was that announcement first made available?
142 yesterday afternoon.
142 yesterday. So, Mr. Kaufman, I will grant Mr. Kaufman the fact that he had a small window to move in. If this announcement had been made 3 weeks ago, hey, you know what, y'all? We're going to keep the registrars open on Saturday, Sunday, and Monday so that y'all can turn your absentee ballots in person. Then your argument that Mr. Kaufman is, popping things last minute would carry a little more weight with the court. But given the fact that 142, while everybody was actually in court with me on another matter, I'm going to give you less credence on that one. Okay.
Your Honor, I think some communication I've had with the Fulton County Chair, we are okay, not enjoying this, but we would be okay with the concept of these being open and receiving the ballots. We just want to make sure that Fulton County's position, and if we can put that in part of the order, is that our observers are actually able to go in and observe where they are physically handing these ballots into the registrars at these 4 locations.
Because that's not in your prayer for relief anywhere.
Well,
anywhere.
Well, arguably, our observers are entitled to go anywhere votes are cast and tabulated under the code. We just want to make as part of the order that we can have that agreement. I'm sure Mr. Kastorf and his clients would want to be sure that they are also notified of the exact location in some of these large buildings, and where, if there's like just one registrar that'll be sitting there, or they throughout the buildings of these, that kind of information, I think would be helpful for all the parties concerned, and we would consent.
Mr. Kastorf, your name came up again, sir.
Your Honor, well, I understand the time pressures that Mr. Kaufman was under. I heard about this case at 7:35 a.m., and so I'm not prepared to present on where observers are allowed. I think that we share the GOP's view that access to elections should be open and free and observed. But whether I could consent at this moment to including a specific claim of relief, a specific entitlement to relief in an order requiring Fulton to do something, I'm not prepared to make a statement on behalf of my client on that. I will say that there is extensive provisions of the Georgia Code that set out where observers are allowed, and I also expect that Fulton will engage with both sides and be open to allowing observers consistent with Georgia rules. So
and just before we get into that, I did not pre-read any of those code sections. I focused on the code sections I thought I was going to be dealing with today.
Judge, you did pretty good for the family court, I think. So thank you.
Yeah, so to be clear, we have no theoretical opposition to open access and view of elections.
Just as long as it's in compliance with Georgia's. Because here's the thing: those registrar's offices that are open, those 4, have been open this whole time. Is that correct, Ms. Joe?
Yes. They've been open for advance voting.
They've been open for people to come in to hand in their absentee ballots the entire time.
They've also had drop boxes, Your Honor. I understand that.
I understand, but we all need to forget the word drop box even exists, because it's not really relevant or germane to this conversation as I see it. So, but those offices, Ms. Joe, North Fulton, South Fulton Annex, downtown, and Union City, were open for absentee voters to hand deliver their absentee ballots.
Having had limited time to consult with our department, I'm going to ask that Ms. Williams jump in if this is incorrect, but it's my understanding that yes, your statement is accurate.
Well, let's put Ms. Williams under oath real quick before I ask her that question about that. Ms. Williams, can you raise your right hand, please? Do you swear affirm any testimony you shall give before the court in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God, or affirm?
Yes, I do.
Thank you, ma'am. Would you please state your name, state and spell your name for the record?
Nadine Williams, Nadine, Williams, Williams.
And what is your official title, ma'am?
Director of the Department of Fulton County Registration and Elections.
Okay. And I'm going to ask you the same question you've heard me ask, but I'm going to ask it directly to you. The Fulton County Board of Elections is keeping open 4 locations. They have announced that they are keeping over 4 locations: the North Fulton Annex, the South Fulton Annex, the downtown office located at 130, I believe it's 130 Peachtree, correct?
Yes.
As well as the main registrar's office in Union City. Is that correct?
Yes.
Have all of those locations been open during the pendency or since early voting began, I believe on October 15th? Have they been open for absentee ballot holders to hand deliver their absentee ballots?
Yes, these are our regular office locations. They're not newly established. These are regular offices that are open year round, and they have been open through the duration of this election.
And is the procedure that is going to be used or that is proposed to be used today, tomorrow, and Monday the exact same procedure that has been in place since early voting began on October 15th?
Yes, a voter can walk in, fill out an affidavit, and drop off their absentee ballot. That is the procedure at all of those locations.
And have all of those locations been open to poll watchers since early voting began?
No, those are our offices. So they're not polls. Therefore, there's no poll watchers that come into the facility. But we do have election monitors that have been in our facility.
And Your Honor, that was my point that I maybe didn't artfully put forward, is credentials are done by location and by day. We have credentials for polling locations. These are not polling locations. And that's why I was talking about meaningful access. And we couldn't even, and when you put a last minute
Mr. Kaufman, hold on. Ms. Williams, I think I understand your concern, Mr. Kaufman. Ms. Williams, has it been possible? Could a poll watcher apply? You said you've had observers. Is there a process in place by which a poll watcher can access these locations, be it from any party?
Right.
Green, Libertarian, Democrat, Republican, doesn't matter.
So again, these are our offices, they're our regular business offices where we conduct elections. It's my understanding, since they're not polls, that we have never, since I have been here, poll watchers in our offices, because they're not polls.
Have you ever had an application for a poll watcher to come to these 4 locations ever, from any party that you know of?
Not. I have never seen a party of any party request to be a poll watcher in our office. No.
And you've been receiving absentee ballots there since this code section has been in place?
For the decade that I know of, they've always received absentee ballots.
So there's been no change in procedure because of the opening of these locations for these additional 3 days?
No, none at all.
Okay. Ms. Kaufman, do you have Mr. Kaufman? I'm going to ask Mr. Kaufman if he's got any questions for Ms. Williams, and then Ms. Joe and Mr. Kastorf, I'll allow you the same.
Sure. Ms. Williams, when did you first receive notice of the intent to have these 4 locations?
Mr. Kaufman, we're talking to her about poll watching.
Okay. Well, I wanted to know when, because we would have, okay.
Well, how would you have known? Because they've been open since October 15th and nobody's applied since October 15th.
Isn't it true that people apply for poll watching credentials, in your experience, for where there are polls, and that is the sole place to apply for?
If you're asking me if we received poll watcher credential letters from all the parties, to go to our polling sites for advanced voting, to go to our polling sites for election day. Yes, we have received those and created badges, etc., in regards to the allowing poll watchers to come into advanced voting and election day.
Right.
Location.
And isn't it true that each a poll application is specific for a specific watcher at a specific poll for a specific day? Correct.
There's no application. What we receive from the parties is a list of their poll watchers and the poll watchers' credential letters. And then we make badges for those poll watchers to go to the locations that the party has requested the poll watcher to be assigned. And the requests we have received are for the advanced voting locations and the election day locations.
Do you consider the Fulton County Elections Hub and Operations Center a poll location?
No, it was a poll location for advanced voting. Advanced voting ended yesterday, so there is no active voting at the Elections Hub. It is not an election day site. It is now an office, and it will be for tabulation. And we have received poll watcher requests from all the parties to view a tabulation at the Elections Hub. And we have created badges and followed procedures in regards to allowing that.
Correct. And when was the application deadline to apply for poll watchers in Fulton County?
It's the same for all the states in Georgia, and I don't have that date in front of me, but we follow the exact deadline per the SOS calendar and the election rule. Okay,
and isn't it true, we can all agree that that application deadline has passed, correct?
I don't have the date in front of me, so I would have to confirm that.
Okay, so is it, you're saying that the Fulton County Republican Party could apply right now for poll watchers, or is that closed?
First of all, the Republican Party has already submitted their poll watcher deadline, their poll watcher lists and credential letters. We've already received that from the Republican Party. And I will look up the date of when the deadline is due, but we've already received that from pretty much all the parties.
But the point being is that the deadline has likely passed. Would you agree with that?
If you give me a second.
She's looking it up now. He's asking her to speculate.
Well, I'll give her a chance to look it up, Mr. Kaufman.
21-2408.
The deadline for the November election, deadline to submit poll watch for designation letters is November the 2nd, which is today.
Okay, and then you would agree with me, you made this press release yesterday, and so how would a party know, strike that. You agree with me, this press release was put out yesterday afternoon, correct? About these 4 new locations, or these 4 locations that'll be open?
Okay, so yes, a press release was submitted yesterday but it's our offices. It is not new polling locations. So there is nothing to report to the poll watchers because I'm not opening new polling sites. These are literally our offices that are open year round every day.
So there would be really no way for someone to apply for a poll watcher location for a place that's not a poll in order to observe this tomorrow or today.
I don't believe the code says that poll watchers go into offices. So I don't know. Somebody would have to tell me if that is allowed for a poll watcher to be watching an office.
And so you contend that you have a voluntary Fulton County monitors and that's the sufficient safeguard. Is that your position?
I'm not understanding your question.
Well, you would agree with me that
I'm not going to ask her to make that legal conclusion,
Mr.
Mr. Kaufman.
Okay.
That's a legal conclusion I'm not going to ask her to make.
Okay. So you would agree with me that it's a fact that neither the Republican Party nor the Democrat Party knew to or filed a poll watcher application for the Fulton County Elections Hub and Operations Center for this weekend, correct?
It's not a poll, so no, they would not.
Okay, and so is your understanding? Strike that, Your Honor. That's where I'll leave it. I think the point's made.
Miss Joe.
The court has already posed all of the questions that I would have asked her, so I have no further questions.
Mr. Kastorf?
No questions, Your Honor.
Okay. Okay. I'm looking at the complaint. I'm looking at the complaint only. That asked me to issue a preliminary injunction and permanent injunction to close, to not permit persons to hand return their absentee ballots in violation of OCGA 21-2-382 and 21-2-385. I do not believe that it is a violation of those two code sections. I find that it's not a violation of those two code sections for a voter to hand return their absentee ballots. The second part of that is issue an injunction not to accept absentee ballots in a drop box today, tomorrow, or Monday, to which I've heard consent from Ms. Joe. And Mr. Kastorf, do you also agree with that position, that that would be impermissible and those votes would be null and void?
Ballots that are dropped in drop boxes.
That are placed into a drop box today, tomorrow, or Monday, if they were able to find a drop box, those votes would not be valid.
We agree that the drop box period is closed. Yes.
Okay. So, I am, I'm not going to grant your prayer for relief, Mr. Kaufman. I think it's permissible under the code section, under 382 and 385, 385A specifically, and 382, I believe it's A as well. 382, yes, both 382A and 385A permit voters to hand deliver their absentee ballots, voters or the other folks authorized under 385A to deliver the absentee ballots. I'm not going to address the poll watching situation because it wasn't pled, so I'm not going to address that at all. But I'm going to deny your relief as requested today, Mr. Kaufman. Anything else from the petitioner?
Well, I'd ask two things. One is that to the extent that there's to the Dropbox that part be granted, and
oh well, yeah, I'm granting.
Yeah,
Dropboxes shall not be in place, nor any votes placed into any said Dropboxes be accepted if they are delivered on November 3rd, 2nd, 3rd, or 4th.
Correct. So
yeah, I'll grant that, sure.
Yeah. And then I guess we probably will ask for a certificate of immediate review if the court will grant that that request.
And while you consider that, Your Honor, may I ask the court to consider it's sticking with its original intent to just deny the relief, because putting into your order that you are granting relief indicates that there is a need and that he has made a showing that we are in violation of the Dropbox provision, which there has been no evidence that we are.
Your Honor, there on that point, it's specific. It's not specific in their publication. It says for hand return. It doesn't say hand return to the registrar's office or anything else. It says hand return their absentee ballots, and these locations had drop boxes, and we're taking their word for it based upon timing when this was done. It's closed. I can't even independently verify, but it would act that as a injunction.
You can't get
that they would-
someone down to Union City and see if there's a Dropbox there, Mr. Kaufman? 'Cause
Well,
that's the only place that had a Dropbox.
the North Fulton Annex had a Dropbox, I believe, Your Honor. I believe I saw that myself.
Miss Brumbaugh's shaking her head. No, it didn't have one.
Granting relief on that point, Your Honor, would essentially be telling the county to continue following the law. And I don't think that that's necessarily what.
Yeah. You haven't shown that they've violated that law. You haven't shown that they have any Dropboxes out. That's a fair point.
I'm not sure when I could do that between filing something at 10 and a hearing at 8 when they're inside buildings now, Your Honor, that are closed.
I'm sure.
No.
The
The Dropboxes were very the Dropbox code section is pretty specific. They're not inside buildings.
No, yes, they are now, Your Honor. They're absolutely are inside buildings and have to be observed and only open during times that the building is open and voting. That was the change. They're not outside. They're not just placed.
And Your Honor, I would also point out that if you grant relief on that point, that does have the effect of potentially making the plaintiffs a prevailing party for their attorney's fees request. And I don't think that's appropriate under the showing that's been made today.
And Your Honor, we would join in Fulton's request. We think as a matter of justiciability, there needs to be at least some minimum showing that there is, in fact, a violation of the law to create a ripe controversy. I take Mr. Kaufman's point that he hasn't had much time to investigate, and the level of showing might be relevant to this court. But here, all we've presented is he hasn't personally verified Fulton isn't violating the law, and that's not the standard for obtaining injunctive relief.
Mr. Kaufman, you're saying they may have that stuff out there. I don't have any evidence that stuff is actually out there, that those Dropboxes are actually there, as you allege.
So there's nothing to be enjoined.
Yeah. Can you show me where a Dropbox is where it's not supposed to be, Mr. Kaufman?
I received an email. My understanding is that there's one being removed today, but I don't know. That's from our correspondence outside of this. I don't know if Fulton County has removed it or not.
So I don't have any Dropboxes out there. So I mean, to get relief, you have to have a violation, correct?
Well, yes, but in all fairness, we had a witness, and I was limited into the questions that I could have asked of Ms. Williams if there were any Dropboxes still out there potentially. I don't know.
Ms. Williams, I'll ask her. Any Dropboxes out there, Ms. Williams?
Okay, so we had a total of 7 Dropboxes. So the ones that have been picked up were Alpharetta Library, C.T. Martin, East Roswell Library, and the Elections Hub. Those 4 have been removed because they get picked up when we pick up the advanced voting equipment. The remaining drop boxes will be picked up at 11 o'clock today when we pick up the advanced voting equipment, and they're currently locked and in a locked room at Buckhead Library, Sandy Springs Library, and Wolf Creek Library. Those will be picked up at 11 o'clock, and those last 3 are not at any of our offices, which of course is Government Center, North Annex, and South Annex. And of course, again, the Elections Hub box was already removed. So to answer your question, there's 3 that are getting picked up at 11 at Buckhead, Sandy Springs, and Wolf Creek, which is not advertised as the offices.
And are they available to the public at this time?
No, they're completely locked inside the vote. The box itself is locked, and the room that the box in is locked.
Mr. Kaufman?
I mean, with those representations, I think it does change a little bit that there are still physically ones not picked up, but with those representations, Ms. Williams, I understand the court's position. Obviously, we want to make sure that they get picked up and remain sequestered until the election day, when they can be used again. Absent that, I mean,
Well, actually, the drop boxes aren't going to be used on election day, are they, Ms. Williams?
No, they're not used on election day. The boxes, per code, were emptied at the closure. All of them were emptied at the closing of advanced voting at 7 o'clock, and locked. So none of them are in use until next election.
Okay. There we go. So I don't believe I have to grant that portion of the prayer for relief and that there's no violation. So I'm going to deny your petition, Mr. Kaufman.
will you grant a certificate of immediate review?
I don't know. I'll think about it. Right now, I got to draft an order.
Okay.
All right. Let me get to drafting, y'all.
Thanks, Judge.
Thank you very much.
Thank you, Your Honor. Thank you, everyone.
Thank you.
Thank you, Your Honor.